as Bonnie was saying, my name is Laura Stone, and yes, I'm a licensed clinical social worker. That was my prior life. And then what I did was I worked nursing homes. I did private care, therapy, did individual therapy with the nursing home residents, did home health. I think I did just about everything. Did expert witnessing in court for immigration and family and dependency court. And then decided and then did it in individual counseling and taught at the University of Central Florida and blah, blah, blah. And then after all that, I went, I should do something else. So let's go to law school, right? Why not? So graduated in 2005, passed the bar and started practicing. So now I have a partner. I'm married to Ruya. We have Ruya and Sterling, and she does just immigration. She's a naturalized U.S. citizen from Peru. And then I do everything else. I do estate planning and guardianship. I thought that was just kind of a natural transition with working nursing homes and, being a social worker as well. And then for kicks and giggles, I like to do criminal and family because, I've got nothing better to do. But it really seems to come in handy with the social work background of understanding because family law is very emotional. You're dealing with all these feelings and stuff. And so I think as a social worker, that kind of helps me. I wouldn't say it doesn't make me go, ugh, sometimes, but it at least helps me understand why people are acting the way they are and maybe help them realize that as well. So, but anyway, what I'm here, and I'm going to share screen because of course I have a slideshow. This is my second presentation of the week. So we all get to share in that fun. So anyway, so here it is. Justice and Care, Ask a Lawyer Social Worker. I thought that was kind of a catchy little title there. We're going to talk about power of attorneys, healthcare surrogates, also what's called a healthcare proxy, living will and wills and trusts. I know I only have about 15 minutes, so I am keeping track of my time. I won't go astronomically fast. I've had to go through things pretty quickly in the past, but anyway, so our first slide, I think it can be a little sensitive sometimes. A proxy. Proxy is under Florida statute 765-401. The proxy is when I'm going to use myself as an example. So let's say I become incapacitated. I'm unable to make decisions for myself, but I've never appointed anybody to make healthcare decisions for me. And I have nobody. I have no parents. I have no siblings. I have no spouse. I have no children. I have nobody that can make that decision for me. That's what a proxy is. It's where you're no longer able to make those decisions. So wherever you may be, let's say you're in the hospital or you're in a nursing home, they can appoint somebody to be your proxy, meaning somebody that can make healthcare decisions for you. Now, you may ask, well, what is the order? Like, who do they pick? Do they pick my neighbor? Do they pick my friend Susie? Who do they pick? Well, in the statute, it actually goes over. Let me put this up here so I can see who may act as a proxy. And it actually goes in this order. We can't jump from A to F. We have to eliminate each letter as we go along for whatever reason. So if you all remember Terry Schiavo, we all remember that, correct? If we were here in Florida, we remember that. The conflict was between who? Between spouse, her husband, and her parents. So let's look at who had priority according to the statute. So first we look, has there been a judicially appointed guardian? Has the court appointed a plenary guardian or a guardian of the person, meaning of that person, that body, those healthcare decisions? If they haven't, we eliminate A. Then we go to B. What's B? The next best is the spouse, is whomever you're married to, right? Is the spouse. Not if you've been living together forever and ever, because without marriage, because Florida doesn't recognize common law. We don't have common law in Florida. I have tons of clients that come to me, well, we've lived together for it doesn't matter. In Florida, you're either dead or alive, you're either married or you're not. That is it. So the spouse. So in Terry Schiavo, the spouse, he was it. Nobody could override him unless they appointed a guardian. But would they appoint a guardian when she's got a spouse? We always look at least restrictive. The next one on the totem pole is an adult child of the patient, of the person. Or if the patient has more than one child, a majority of the adult children. Coming from nursing homes, you'd always get 4 or 5 kids and everybody nobody could agree and it was always a mess. So either an adult child or a majority of the adult children. A parent, like another parent comes in fourth, right? The adult sibling, or if it has more than one sibling, a majority. Whoops, sorry about that. This thing is sensitive. I'll take my hands off. If there's no adult sibling, then an adult relative of the patient that has exhibited special care and concern for the patient and has maintained regular contact, maybe a cousin or a sister-in-law or somebody that knows this person and has provided, knows what they would want in their end of life. And a close friend would be the next one. And I actually have had the hospital, they've actually been out looking for somebody that knows this person. They actually heard that the person, this was quite a few years ago, the patient frequented a bar in the local neighborhood. So they actually sent a PI out to this bar and they actually found somebody. Oh, he was here every day. I talked to him. So close friend, somebody that knows this person and knows maybe what their wishes are. And then finally, we have a licensed clinical social work proxy. I actually helped kind of write this statute in regards to including the proxy way back when. Back in the day, it was so many years ago. I think it was even before I got my law license, but I may be wrong. But a clinical social worker license pursuant to Chapter 491 or who is a graduate of a court-approved guardianship program. Such a proxy must be selected by the provider's bioethics committee and must not be employed by the provider. So that's a tricky part. You're in the nursing home and there's nobody to make healthcare decisions for you, but the nursing home wants to appoint an LCSW proxy. They need to have a bioethics committee that approves that proxy to act. They can't just appoint somebody. Now, what happens sometimes is as long as it's a bioethics committee, if the provider does not have a bioethics committee, then such a proxy may be chosen through an arrangement with the bioethics committee of another provider. Maybe the hospital. The hospital with their bioethics committee has approved that licensed social worker. So the nursing home is now saying, okay, can we take your proxies and use your bioethics committee? And so that's something where you can do when you don't have that bioethics committee. But understanding the licensed clinical social worker does not have carte blanche to just make decisions. When it's an end-of-life decision, that licensed clinical social worker has to meet with the bioethics committee to discuss it. Back in the day, I was a licensed clinical social work proxy, and I met with many bioethics committees at the hospital to discuss end-of-life decisions because I don't know this person and I need input from the multidisciplinary team to find out, okay, how do we think this is in best interest? What will be the outcome? What's the prognosis? All of that kind of stuff. So, and the facility also needs to show before they appoint an LCSW proxy, what they've done to try to find somebody that fit the other categories. So that's a proxy. That's when you have nothing in writing and you have nobody to make decisions for you. The next thing we have is a healthcare surrogate under 765.205. The surrogate is somebody that's appointed. Again, I'm going to use me as an example. I have the ability, and I understand and I'm fully aware of appointing somebody to make medical decisions for me. So I do up a document. I say, I want Joan to make healthcare decisions for me. And so, I want to make sure, though, that I consult with Joan and Joan knows what I want. That she's able to say, yes, we've spoken. This is what her wishes are. I always tell families, please talk to whoever you appoint because you don't want them to come to the end and go, I don't know. And then they're making a decision that they feel comfortable with not that you made. So, so there's a healthcare form on there. It says you're appointing them. I always recommend people do an alternate because you never know. I never know what's going to happen to Joan. Joan may not be there, when something happens to me. So now I have an alternate of Bonnie. So Bonnie, in the event that Joan is unable or unwilling, Bonnie can then make decisions. I always want to have backups because things happen, especially if you've got a big age difference. I have a mom that's going to become, of the son, and I always say, you need a backup. Power of attorney. A power of attorney is somebody, we have a durable power of attorney and a regular power of attorney. A power of attorney under 709 says there's a regular power of attorney, is a specific power of attorney to do something for you. Okay, I'm going overseas. I'm going to live overseas for 3 years, but I want to sell my house. That's going to be really difficult overseas, right? So I give my parents power of attorney to sell my house. Okay, they can deal with the mortgage company, they can deal with the title company, they can do closing, everything. Once that job is done, that power of attorney is null and void. So I'm just doing it for a specific purpose. Now, there's a durable power of attorney. A durable power of attorney generally encompasses everything. I think I have 22 points in my power of attorney, my durable power of attorney, that are covered, and I continue to add more. It's sad, but I do, because I'll do it, and then somebody says, oh no, it has to say this. The bank is requiring this. So then I got to go in and I got to add that. So I just keep that when I keep passing and doing my power of attorneys. So a durable power of attorney, again, I have to have the ability to appoint somebody to be my power of attorney. Somebody else can't appoint somebody to be my power of attorney. I have to have that. So I have to have the ability to do that. And I'm appointing somebody. In my durable power of attorneys, I also include healthcare decisions just to cover the gamut. And again, a durable power of attorney is something that can cover everything. And also, it stays alive even after I become incapacitated. So it doesn't become void once I become incapacitated. It stays valid even during incapacity. And again, I always encourage people, have an alternate, because you never know what's going to happen with the first one. And you don't want the person to be left high and dry without anybody if they're becoming incapacitated. So I always include banking. I find that banks want more and more specific language in it. Like, for example, we do a lot of Medicaid planning. You need a qualified income trust. Your income's too high. I put in the document, to deal with the bank and establish any trust. Well, somebody took that to the bank, and the bank, no. We want specific qualified income trust. I'm like, so I had to go back with the person and include that. So now I include that. So it seems like I'm adding and adding. Pretty soon the document's going to be like 30 pages. But these are the items, that are in the statute that I put into it. I make sure that I cover everything: contract, withdrawal by check, receipt statements, purchase cashier's check, endorsed checks, apply for and receive debit cards, charge or draw on any line of credit, consent to an extension of time of payment. Now, understand, with the power of attorney, it becomes valid the moment it is signed. So you want to make sure that you're appointing somebody that you can trust. It's not going to take that power of attorney to the bank and rob you blind. So you want to make sure it's somebody that you trust. So, okay, hold on a second. Am I getting there? Hold on. Let me make sure I got this. Okay. Okay, then we have living wills under 765-302. And I always get people coming, I want a living will where I give my house to somebody. Well, no, that would be a will. A living will, I always say, the easy way to remember it is my living body. It's taking care of my living body. What do I want done while I'm living, while my body is here on earth? So it allows us to express our wishes. If there's 3 things in the state of Florida that for your living will to take effect, you have to be in a persistent vegetative state, you have to be in an end stage condition and no hope of recovery. As long as 2 physicians certify that those are the 3 elements and you fit them, your living will kicks in. So what does it mean? Living will. This is what I want done in the event that I fit these 3 criteria. I want to be kept comfortable, maybe or maybe not. I want to be fed by a tube. I don't want any machines. I don't want to be resuscitated, all that. You can put all of that in a living will, or you can just simply say, I want no extraordinary measures. I just want to be comfortable. I don't want any heroic measures. I just want, what's done. Again, a living will, I have to be competent. I'm the only one that can sign it. Nobody else can sign it for me. I'm the only one. My power of attorney can't sign it. My healthcare surrogate. These are my wishes. And again, when you're appointing somebody, make sure they know your wishes. Sit down with them and discuss it and make sure they're able to follow through, because sometimes, like I say, you don't discuss it. They get, oh my gosh, I can't lose my mom. And they start doing their own thing. So make sure that it's somebody that can follow through and that you trust and can take the reins with you. So, okay. Now, wills and trusts, the differences. A will is a last will and testament is a document that outlines your wishes for asset distribution, maybe guardianships of minors or who else. The last will and testament is this is how I want everything to go, and it needs to close at some point. You go through the probate process, it has to close. A trust can remain open. Now, not for perpetuity, but it can remain open. I want my grandchildren to have $10,000 when they graduate from high school. Then I want them to have another $10,000 when they go to college. Then I want them, so you can progress. You can say how you want things done. A will, it has to go out and close. It cannot remain open. It has to close. So that's if maybe, I always say wills are good for people that have simple stuff, a home, bank accounts, stuff like that. A trust is better if you want stuff to be distributed over time, or you have multiple properties. Because as you all know, your homestead is protected, but you only get one homestead. So if you have multiple properties, subject to creditors during probate. So a trust is always good to put them in, so then it can just pass to the person, the what I want to say, the beneficiary. So without having to worry about going through probate. So, will, you must be of sound mind, understand everything that you're signing. It must be in writing. It can't be something written. Whether it's typed or handwritten, we call handwritten holographic. Oral wills cannot be used and are not recognized unless you're a member of the armed forces. You must sign your will at the end, be witness, have it witnessed by witnesses and then signed in a notary. Clearly identify your beneficiaries and be specific about how you want your assets and properties to be distributed, and appoint an executor, and again an alternate executor in the event that that person is unable to follow through. A trust is a legal entity that allows individuals to manage and distribute their assets for various purposes. You want it to go to charities, or you want it distributed over time. You don't want your 16-year-old grandson to get all your money, because chances are, at least, even to wait beyond 18, because the law is when that grandson turns 18, he gets it. How many 18-year-olds can deal with that kind of stuff, right? They generally blow it. So maybe you want it over time. That's perfect what a trust is for. So there's revocable living trust. That's you're the grantor. As long as you're alive, you can take things in and out. Irrevocable, you become incapacitated or you die, it's now irrevocable. Your trustee has to go by the terms of the trust. Testamentary is it's within a will. It hasn't come into existence yet, but it will once you pass away. Special needs trust, if you have a child that has a disability, those special needs trusts help them kind of, how do I want to say this? Protect them under Medicaid, and then charitable trusts, of course, to benefit charities. A trustee is a person or an entity. You can have a trustee in a bank or an individual. Of course, we have our uniform trust code here. Homestead property. Homestead property can be placed into a trust without losing its homestead status. At least it has up till now. The case law says that. Provides guidelines, the trustee powers, what are the trustee powers, and then the beneficiary rights. Beneficiaries are entitled to, from the trustee, an accounting of what's in the trust. because the trustee has a fiduciary duty to the beneficiaries. So I think I did okay. So here is my information. Please feel free to reach out to me. I'm here for you all to answer any questions that you may have down the road. I know we're going to have some question time here, question and answer time, so I'm going to stay for that. But if you're unable to stay or you have more questions, please feel free to reach out. I just, I'm on Spotify, I do podcasts, I'm on Instagram, I'm on Facebook, I'm on YouTube, all that kind of stuff. So I do a lot of informational and educational videos, so you can watch them if you're ever bored and, the power goes out and all you have is your phone left, you can watch them. So thank you so much for listening. And I hope that I was able to provide you with the information that you need.